What is an irrevocable trust? The term irrevocable trust refers to a type of trust where its term cannot be modified, amended, or terminated without the permission of the grantor's beneficiary or beneficiaries or by order of a court. The exact rules can vary by state. The grantor, having effectively transferred all ownership of asset into the trust, legally removes all of the rights of ownership to the asset and the trust. Irrevocable trusts are generally set up to minimize estate taxes, access government benefits, and protect assets. This is in contrast to a revocable trust, which allows the grantor to modify the trust but loses certain benefits such as creditor protection. How an irrevocable trust works. Irrevocable trusts are primarily set up for estate and tax consideration. That's because it removes all incident of ownership, removing the trust asset from the grantor's taxable estate. It also relieves the grantor of the tax liability on the income generated by the asset. While the tax rules vary between jurisdictions, the grantor cannot receive these benefits if they are the trustee. The asset held in the trust can include a business, investment asset, cash, and life insurance policies. Trusts have an important place in estate and legacy planning, but there is a downside, the cost. Setting up any type of trust can be complicated enough that an attorney is necessary. And this means that people may end up spending a few $1,000s or more in attorney fees to set them up. Irrevocable trusts are especially useful to individuals who work in professions that may make them vulnerable to lawsuit, such as doctors or attorneys. Once an asset is transferred to such a trust, it is owned by the trust for the benefit of its beneficiaries. Therefore, it is safe from legal judgment and creditors since the trust will not be a party to any lawsuit. Today's irrevocable trusts come with many provisions that were not commonly found in older versions of the instrument. This addition allows for much greater flexibility in trust management and distribution of assets. Provisions such as decanting, which allows a trust to be moved into a newer trust with more modern or advantageous provision, can ensure that the trust asset will be managed effectively. Other features that allow the trust to change its state of domicile can provide additional tax saving or other benefits. Although they are commonly associated with the very wealthy, trusts are an important piece of estate planning for anyone, regardless of income status. Types of irrevocable trusts. Irrevocable trusts come in two forms: living trust and testamentary trust. A living trust, which is only known as inter vivos trust, is originated and funded by an individual during their lifetime. Some living trust examples are irrevocable life insurance trust, grantor retained annuity trust, spousal lifetime access trust, and qualified personal resident trust. Charitable reminder trust and charitable lead trust. Testamentary trusts, on the other hand, are irrevocable by design. That's because they are created after the death of their creator and are funded from the deceased estate according to the term of their will. The sole way to make change to a testamentary trust is to alter the will of the trust creator before they die. Irrevocable Trust Use. An irrevocable trust has a grantor, a trustee, and a beneficiary or beneficiaries. Once the grantor places an asset in an irrevocable trust, it is a gift to the trust and the grantor cannot revoke it. The grantor can dictate the term, rules, and use for the trust asset with the consent of the trustee and the beneficiary. Irrevocable trust can have many applications in planning for the preservation and distribution of an estate, including to take advantage of the estate tax exemption and remove taxable assets from the estate. Property transferred to an irrevocable living trust doesn't count toward the gross value of an estate. Such trusts can be especially helpful in reducing the tax liability of very large estates. to prevent beneficiary from misusing assets, and the grantor can set conditions for distribution. Thank you.